Friends and family of Eric Garner have been calling for criminal charges in his death since the Staten Island man was killed during a July arrest. Today, a grand jury began hearing evidence to determine if that will happen.
I'm feeling pretty confident about the whole situation. I believe that justice will be served.
America still sits on a razor's edge over the events in Ferguson, Missouri. This despite, and likely because of the legal and proper findings of a grand jury. But we are awaiting another grand jury decision that should be paid closer attention, for this one truly speaks to a case of evident justice between law enforcement and an unarmed suspect. Listen more as we welcome to MidPoint from the law offices of O'Brien and Ryan, LLP in Philadelphia, and the person we turn to first for our legal advice, Heather Hansen. Heather, always a pleasure to see you. Thanks for being here.
Great to see you, Ed.
Heather, you are exactly right in what you have said when you wrote me recently on this, shocked at the lack of attention to the Eric Garner case. If you would, just give us an idea again of what it was, because this is where the gentleman was being arrested for selling untaxed cigarettes, and it comes into what is basically an illegal, according to the NYPD manual, chokehold on the suspect.
Right. Mr. Garner, the father of 6, was selling untaxed cigarettes and was being arrested by an officer, Paterno. The officer asked him to accede to arrest, and he refused, and the officer then took him down in what looks to be on the video as a chokehold. A chokehold is forbidden by the New York Police Department. And the gentleman cried out that he could not breathe, and he ultimately died. All of this is on video. It's video that we have seen over the course, this happened back in July, that we have seen over the course of these months. Now a grand jury has been meeting to determine whether or not the officers involved in that arrest should be indicted.
Let's go ahead and talk about, we have to talk about the differences between Ferguson and this, simply because no matter how we look to avoid it, people will say it will be a police officer, a white police officer, and a black suspect. I mean, Heather, look at this legally and give us a brief idea of what you think the grand jury is going to be looking at here that they would not have been looking at, for instance, in Ferguson, realizing, of course, there were no shots fired in this one.
The differences are night and day, Ed. I mean, in Ferguson, you've got a situation where the officer was able to claim self-defense. And as we talked about last week, the physical evidence highly supported his claim. Here, there's no claim of self-defense. That is not what the police union or the officer's lawyers are going to say. What they're going to try to argue is that it was a takedown as opposed to a chokehold. But these cases are very different with regard to the defenses. In addition, as we've seen, for example, in the Ray Rice case, that when there is video of an event, it really has an impact. And here, you know, many have decried the need for video cams and cameras on police officers' uniforms. Here we actually have the video. So I would be surprised if there isn't some sort of an indictment in this Garner case. The one last difference, and it's an important one, is that there haven't been any leaks. We've barely heard about this grand jury that's been meeting for so long. So we don't know, for example, for sure, whether or not the officers involved have testified. But I think the weight of the evidence in this Garner case falls much more heavily towards indictment than the weight of the evidence did in the Officer Wilson case.
And we are still waiting for the grand jury to come back. They still may come out sometime today, but again, we're in a holding pattern on this one, and we'll wait. Let's go ahead and spin to Ray Rice right now. Interesting. Could Ray Rice file a case against Roger Goodell? Well, certainly at least against the National Football League for defamation.
You know, the case against the National Football League would be a little bit more difficult. This collective bargaining agreement that these players are employed through really puts them in a tough position to sue various members of the NFL in their professional capacity. So, for example, we saw back when the New Orleans Saints, some of those players were alleged to be involved in something called Bounty Gate, where they paid off players to do certain types of hits. During that case, one of those players sued Goodell for defamation. That case was thrown out of court, but the judge didn't say that it didn't have merit. What she said was that it was bound by the terms of the collective bargaining agreement. That may happen here as well. However, Goodell, having come out and given press conferences and given so many public statements about his opinion as to whether or not Ray Rice had told him the truth, and probably being misleading in that respect, gives Ray Rice a foot up on that other case.
And this also, don't you have to prove malice? And isn't that one of the tougher things to prove in a court of law?
Not everyone has to prove malice. Ray Rice would because he's a public figure. But he would have an easier time because the retired judge who heard the arbitration in Ray Rice's case actually came forward in her opinion and supported the idea that Goodell knew that Ray Rice had told the entire story and yet came forward and acted as though there was some new information that led to the further suspension.
All right, about 2 minutes we got left here. I think this is fascinating here. This is on Facebook Free Speech that the court is looking at. A man who started to post violent rap lyrics from other songs and then his own, threats against his wife, arrested, charged with making threats over the internet. The appeals court upheld the conviction. Doesn't this come down again to taking responsibility? This is not necessarily a First Amendment issue to me. This is if you make some sort of a threat, doesn't that then supersede a First Amendment right of free speech?
Well, Ed, you would think so. I mean, if not, then we can't have a law against making threats over the internet. His argument is that this is artistic, that rap lyrics, and what he wrote was also rap lyrics, that these were artistic expressions rather than actual threats. And he had, he says, no subjective intent to threaten her. Now, he's got an uphill climb here because there was a restraining order out against him. So he knew that she felt threatened. He also threatened FBI agents. He threatened a school. So in my opinion, the First Amendment should not outweigh a person's right to not feel threatened and to feel secure in their own being. This case has a huge impact on domestic violence cases because a lot of times those people who threaten their spouses or partners are only kept at bay, whether it's by restraining order or by arrest, because of arrests based on what they threaten on Facebook.
Well, that's what we're coming to. I got about 30 seconds left here, but then if you post a lyric from a rap song, it could be a threat. You can just fall back and say, I didn't mean it. What's going to stop somebody from actually following through on that threat? It seems to me that you have to stop the threat no matter what.
And that's why the lower courts have found that it doesn't matter what you subjectively intended, it's what a reasonable person would get from your threat. So, you know, if there's some paranoid person who's out there saying, I find this to be a threat, and a reasonable person would not agree, then you're fine. But if a reasonable person would feel that the types of things that you're posting on Facebook are a threat, you will be arrested.
Yeah, we can't climb into your head and figure out how you meant it, but the person who then was the target of it, we know exactly how they felt, correct?
That's right. That's right. A reasonable person.
I'm getting better every day at this law stuff. But then again,
You
don't worry.
are. It's true.
Yeah, please, no, don't hire me. I come to you. That's why we do that. Heather, it's always a pleasure. Have a great week, and we'll talk to you again soon.
Thanks, Ed. Take care.
Okay, you too. We're back after a break to check on the new week and Wall Street. And that features hackers going after insider information on medical and pharmaceutical companies. That and so much more when MidPoint continues, where we question everything.